For those people who came hoping to see Charlotte Davis give a talk on fraud, she can't be here, and you're going to have to put up with me on my own for the next 40 minutes or so. In the case of Havel USA and Seaton, Lord Justice Longmore quoted Lord Hardwicke, who in 1759 said, "Fraud is infinite." He was talking about the ingenious ways in which fraudsters can wriggle out of the strictures that law might encumber them with and get round them. And so the law shouldn't have defined limits when it came to fraud. But you'll be pleased to know my talk today isn't infinite. It's going to be about 35 or 40 minutes. And I'm going to cover the following 5 topics. Firstly, what is fraud and why does it matter? Secondly, pleading fraud in employment cases. Thirdly, breach of fiduciary duties. Then I'm going to cover a couple of economic frauds, the most common economic frauds that come up in employment cases. And lastly, some litigation tips. So kicking off, what is fraud? And I'm talking in this next 30 minutes or so only about civil fraud rather than any criminal offence. It should be a simple answer. I had a look in the leading textbook, Grant and Mumford, and they start the tome by saying, over at least 3 centuries, judges and commentators have observed that it's elusive of any hard and fast definition, which is troubling. It may be easier to say what fraud is not than what it is. It's not a single cause of action. Instead, it's a general term describing a range of different activities, which might give rise to a range of different remedies and different causes of action. And I'm going to be looking at some of the most common in the employment sphere. The link between all the different causes of action is that they involve, in the main, deliberate activity and usually, but not invariably, dishonesty. Fiduciary duty is the exception to that, but other than that, with fraud, you're normally alleging a deliberate cause of action. So why does it matter? You may be thinking that as employment practitioners, fraud has little to do with your day-to-day existence. And you may be wondering why on earth we're talking about it in an employment seminar. But the reality is there are many opportunities for us as employment lawyers to think about fraud and to bring claims or defend claims for errant employees who've committed fraud during their employment. Preparing for this talk, I looked on the internet and I found a few interesting statistics. According to the police site Action Fraud, 1 in 5 small companies in the UK suffer from employee fraud. And in this talk, I'm not just talking about small companies, of course. And if you're surprised at how common that is, spare a thought for companies in the USA, which in another article I read suggested that 2 out of 3 US small businesses suffer employment fraud. I don't know if that's surprising, maybe not for Americans, but I don't know if they're just more dishonest than us or maybe they're better at catching them. But it comes up a lot in employment. So if you're an employment lawyer, cases involving fraud are likely to come up in a whole variety of different scenarios. False expenses claims are really common, and almost invariably, whenever I've litigated a bonus claim, a false expenses claim is the defence to paying a bonus, and so it comes up as a defence, if not a cause of action. Employees taking bribes by third parties, creating or generating false payments as a way of diverting assets or business from the employer, making false representations about qualifications when employees apply for jobs, or perhaps most importantly for us as business protection lawyers, exploiting assets and information on behalf of the employer, or taking an employee or team of employees by a new employer. And the advantage that pleading fraud in those situations can provide are many, and I'll deal with a few of them later on. But the downside, or something to be aware of, is that pleading fraud, making allegations of fraud, is very serious. It can have a hugely detrimental effect on a defendant to a fraud claim. Making an allegation is not normally something that can be subject to the laws of defamation. So if you make a fraud allegation in the context of litigation, that you'd have a qualified or absolute privilege in respect of a defamation claim. And that sort of allegation lives with a defendant, whether or not they're guilty, for years on the internet and generally in society. So there are a series of legal safeguards that have been developed to ensure that these allegations aren't made without substance. And it's important that we as practitioners are aware of these safeguards, because they impact on us both in terms of compliance with the rules and in respect of our professional obligations. And the three specific points I want to outline are the professional obligations on us, the CPR rules, and the standard to be approached when pleading fraud. The first point is professional obligations. The onus is on us as legal professionals to ensure that we're not putting forward a case without a proper foundation. So as set out on the slide, for solicitors under Rule 2.4 of the Code of Conduct, you've got to make sure that you only make assertions or put forward statements, representations or submissions which are properly arguable. And there's a similar obligation for barristers when it comes to drafting documents, that barristers have to have clear instructions and that it has to be based on reasonably credible material. And so it's not just that if you don't engage with your professional obligations, the claim will be struck out and there might be cost implications, and perhaps wasted cost implications, but also there might be professional regulatory obligations that are engaged. And so often in fraud claims, there are threats to report to the regulator. You've got to be wary of these. If you're acting for defendants, making an unjustified threat to report to the regulator is itself a potential regulatory breach. So be careful with that one. Under the CPR, there are specific rules dealing with pleading fraud as well. And these tie in with the professional obligations when pleading fraud. So CPR Part 16 applies to all cases, and the practice direction 16 paragraph 8.2 states that a claimant must specifically set out any allegation of fraud and also notice or knowledge of a fact, which is important because many fraud claims will be based on inference. So you've got to set that out in the pleadings. And the Chancery Guide, paragraph 4.8, has similar obligations, that a party shouldn't plead an allegation of fraud, dishonesty or malice without setting it out clearly. And the next sub-paragraph goes on to emphasize that you mustn't make the allegation unless there's credible material to support it. And absent that, the claim can be struck out and wasted costs ordered. The third point I was going to talk about is the standard of proof. it's sometimes thought, and it used to be thought, that a higher standard of proof applied in fraud claims. That's not quite the case. It's technically the normal civil standard. I say technically because it's the normal civil standard with a twist. And that's explained in the Henry Boot case, where it was said that although the standard of proof is the same in every civil case, where fraud is alleged, cogent evidence is needed to prove it, because the evidence must overcome the inherent improbability that people act dishonestly rather than carelessly. Obviously, the judge didn't have American employees in mind when he said that. So there is a tension between the assertion, the rule in all civil claims that it's a balance of probabilities test, and yet in fraud it's balance of probabilities, but you need really cogent evidence to get over that 50% hurdle. So the reality is it might be a little bit higher than 50%. But as the judge stressed in the last sentence of the quotation I've set out, you're making the assessment in light of all the actual circumstances. So all these cases depend on the circumstances themselves, and often there'll be allegations based on inferences. And if you're relying on inferences, you've got to set out the facts which justify the inferences. So what are the pros and cons of pleading fraud? The first question to ask yourself is, do you need to plead a case in fraud at all? You might have a straightforward breach of contract claim or a direct tortious claim, which is much easier to plead based on clearer documentary evidence that doesn't engage all the boring technical strictures and professional obligations that I've been talking about. And if you can get home in that way and get an easy judgment against a solvent defendant, great, that might be more straightforward. But if you can't, some of the cons in pleading fraud are the onerous pleading rules that we've talked about, the difficulty in proving allegations given the judge's disinclination to find dishonesty, and thirdly, that it may escalate the temperature in any case. I know we sitting here are all very mild-mannered litigators, but perhaps when allegations of dishonesty are made, that tests are resolved. Of course, there are significant pros of pleading fraud as well. Firstly, the court takes a much more generous approach to causation. If an intentional wrong has been established, the court has a flexible approach in terms of causation and damages, which favours the claimant. So it might allow a claimant to recover consequential losses that couldn't be recovered in a straightforward contract or negligence claim. Secondly, there is an extended limitation period in fraud. So sometimes people rely or forced to rely on fraud claims because they've missed the primary limitation period. It doesn't start running until the claimant knew of the fraud or could reasonably have, with reasonable diligence, have discovered it under Section 32 of the Limitation Act. And finally, in terms of remedies, a fraud claim opens up the field to a whole range of different remedies, including interim remedies like interim relief and disclosure orders, freezing orders, and final remedies, including gains-based claims, not simply damage-based claims. I want to talk about some of the strictures on pleading fraud in a little more detail. I'm going to do this with reference to a recent case of Ivy Technology and Martin. And I refer to this case not simply because, like all barristers, I only ever want to refer to cases that I've appeared in and won, but because it does have some tangential relevance to the issues we're talking about. Ivy was a case where the claimant, Ivy, was suing for a fraudulent sale of business, and part of the claim involved a conspiracy with the defendant. My defendant was the second defendant, not mentioned on the name of the slide. And the first and second defendant were alleged, amongst other things, to have conspired to breach the first defendant's non-compete covenant. So it's the sort of claim that is familiar to us as employment lawyers. This happened to be a commercial claim, but it's very similar to exactly the sorts of claims that proceed in the High Court based on employment claims that we deal with every day. The first point is that arises from Ivy. Now, the reason this was considered was because the defendant, or my client, applied to set aside a freezing order. So it was the claimant got a freezing order, and the second defendant, who was the only solvent defendant, applied to set it aside. And part of the basis for setting it aside was that the case in fraud just hadn't been pleaded properly. And the court analysed the obligations of pleading and set them out in a really coherent, easy way, which have been quoted and relied upon many times since this case came out, including in the case of Mackenzie, which Mackenzie in EAA, which Georgina was talking about before lunch, which a number of us in chambers were instructed in. The first point made in Ivy is that conspiracy claims must be pleaded to a high standard, especially when they involve dishonesty. And the reason is to protect the defendant from allegations of fraud. And secondly, when pleading them to high standard means setting them out with particularity. And this leads to the second point, that they must be clearly pleaded. So it's not just particulars, but clearly pleaded with convincing evidence. And the evidence is important even at the interim stage, as was held in Ivy. And when this was an unlawful means conspiracy claim and a general inducement claim, and it was held that all the strictures that apply to fraud generally apply to these types of claims. So all the specific facts when you're pleading this sort of cause of action must be set out, even when you're pleading unlawful means conspiracy or inducement of breach of contract. And thirdly, it was said that the court in Ivy relied on CEF and Monday to the effect that it's a grave allegation to make a charge of conspiracy against the defendant. It should not be lightly made, and it must be clearly pleaded. And CF and Monday is a team move case, which should give us all pause for thought before commencing conspiracy claims based on unlawful team moves, because in that case, the claim was thrown out. And it was held that it's not enough to rely on mere suspicion. So Ivy pulled all these principles together in a really useful way. It's also quite a useful case to give a warning for people acting for defendants in fraud claims, because although we had a big success in the 2019 hearing, setting aside the freezing order and getting parts of the claim struck out, the problem in acting for defendants is that there's a real risk they are in fact fraudsters, and that's why I haven't referred to the outcome of the trial in this talk. Secondly, cogent evidence is required, and the reason for that is that there is a strong presumption that individuals will be innocent at the beginning unless they've been shown to be dishonest, and that is and that's, it comes from a whole number of cases that I've referred to the Jafari, Finney and Skillglass case. But the presumption that individuals should be presumed to be innocent unless they've been held to be fraudulent already is so strong that in Ivy, my client, who had been held to be a VAT fraudster previously in Jersey, was nonetheless held not to be a risk of dissipating his assets on the specific facts of this case. I'm not sure it's because the court accepted my submission that VAT fraud, it was the opposite of dissipation. And dissipation, I don't think it was because of that. But it shows that you've got to prove specific dishonesty with respect to the specific allegations. Secondly, although the case is to be proved on the balance of probability, the more serious the allegation, the more cogency is required. And that's because, again, of the inherent improbability that people will act in this way. And thirdly, an important point is that courts cannot infer dishonesty from facts which are consistent with honesty. So when you're pleading a case in fraud, don't simply allege facts which are consistent with, for example, negligence, because that's a basis on which the court will strike it out. But I hear you say, when you're acting for claimants, defendants are dishonest. How can we have all these strictures on us when those dishonest fraudsters get away with it? Well, the truth is, it's not just hard. The court law isn't just hard on claimants. It's hard on defendants too. The courts recognise that fraudsters will try and shroud their claims in secrecy, and so there is a balance in reality that the courts adopt. On the one hand, the impulse for the courts to ensure that a party knows the case pleaded against it, and on the other hand, to ensure that a claim isn't shut out of the judgment seat merely because the fraudster has clouded the case in and shrouded the case in secrecy. And so Lord Supreme Justice Sales, as he now is, or Mr. Justice Sales, as he was then in the Bord-Namona horticultural case, said that the courts should adopt a generous approach to pleadings. And that goes hand in hand with the fact that the bar for summary judgment or strikeout for a claimant to overcome at the early stages is pretty low. So, and courts are unwilling, just like in discrimination claims in the employment tribunal, the High Court is unwilling to summarily determine allegations of fraud where it surmounts an initial hurdle. So, specific types of causes of action. Firstly, I'm going to deal with fiduciary duties and then talk about a couple of other economic torts. Why are fiduciary duties important in employment fraud claims? Well, it's because they are a flexible remedy and can apply to a wide range of factual circumstances. And fiduciaries, of course, aren't just statutory directors, the people on the first point, who are always fiduciaries and who have an obligation to act in the best interests of the company they work for, not to make a secret profit and avoid conflicts of interest. And these are statutory obligations. But there may be other people who are fiduciaries as well. Now, simply because someone is a highly remunerated, highly respected employee doesn't in and of itself give someone fiduciary obligations. An employment relationship is at its heart contractual. You must go further than that. And in the seminal case of Customer Services and Ranson, Mr. Justice Elias, as he was before he went to the Court of Appeals, said that fiduciary duties result from the fact that within a particular contractual relationship, there are specific contractual obligations which the employer has undertaken, which place him in a situation which imposes rigorous duties. So equity imposes these rigorous duties arising out of specific obligations. So when analysing whether or not an employee has fiduciary duties, you've got to look at the contractual duties, see if they give rise to fiduciary duties, and look at the specific obligations they have. So, for example, an employee entrusted with money will have fiduciary duties in respect of that money, or an employee who receives a bribe will obviously have fiduciary duties to account to the employer, or specifically entrusted with a particular task. And most commonly, confidential information gives rise to fiduciary obligations. In the context of fiduciary duties, a breach can be characterized as dishonest if the fiduciary acts or fails to act, either knowing that the course of action they've taken is contrary to the interests of their principal, or being recklessly indifferent to whether it is. Put in another way, there's a breach if the employee deliberately and without honest belief that he is acting in the interest of his principal carries out some act, and it must be deliberate in the sense that the act is deliberate. You can't be careless and breach of a fiduciary duty, but conscious intention isn't necessary to demonstrate. But the advantage of pleading breach of fiduciary duties is that you don't need to establish dishonesty. It's enough to show that the breach occurred. If you can show dishonesty, that's an advantage, for example, in disapplying the limitation provisions. But be careful, because even if not pleading dishonesty, the strictures that I talked about in terms of pleading still apply. You've got to set out with particularity the basis on which the fiduciary owes those obligations. In terms of remedies for fiduciary duty, these arise in equity rather than at common law, and give the court a wide canvas to grant relief. The starting point is that equitable remedies compensate the claimant, but you don't need, as a claimant, only to seek compensatory damages. You can, at the same time, plead a claim for an account. At some point, you'll have to make a decision, make an election, which remedy you're seeking, but you can plead an account as well. So you get to say that the defendant must account for what he or she has gained rather than simply for what the claimant has lost. And that's a great remedy to seek if, in fact, the claimant hasn't suffered any direct loss, but the defendant has made a gain because of the breach. And where an individual has gained benefits because of their breach, these benefits will be held on constructive trust for a claimant. And the advantage of that is twofold. First, the claimant gets priority in any insolvency or bankruptcy proceedings. And secondly, the claimant gets the right to take the benefit of any appreciation in value of the gain made by the defendant. And lastly, the advantage of pleading a claim in fiduciary duty is that, in principle, it opens up accessory liability claims against third parties, most notably when the third parties have dishonestly assisted in the breach, which leads seamlessly on to the third party torts element of the talk. And I'm going to talk about inducing breach of contract and conspiracy as the two economic torts most regularly relied upon by employment lawyers. This group of economic torts are based on intentional conduct causing damage to the claimant's economic interests. And there's a requirement for all of them to show some intention to injure on behalf of the defendant. And most of the economic torts arose in the 20th century in respect of applications for interlocutory relief arising out of trade union activity claims. And claims were brought as economic torts because there was no other contractual, for example, claim available. So I think we as employment lawyers can be proud for our part in the formation of this area of fraud. But inducing a breach of contract has a longer history and goes back to another employment related case, Lumley and Guy, where Lumley, a theatre owner, had a contract with the singer Johanna Wagner, and Mr. Guy interfered with the contract and got her to come and sing at his theatre, and Mr. Lumley brought a claim, and Guy was held liable for the tort of inducing breach of contract. So that's Lumley and Guy liability, which we now call inducing breach of contract. And more recently, the principles of this tort have been assessed in OBG and Allen, brilliant masterly account by Lord Hoffman of the obligations and third-party torts, and assessing the mental element required for showing these breaches. Inducing a breach of contract is philosophically, that's the right word, distinct from other torts of primary liability. So, for example, causing loss by unlawful means is a tort of primary liability, which requires proof of independent unlawful conduct. But inducing a breach of contract is a secondary liability claim, and it's most often seen in the employment scenario where for example, a new employer induces the ex-employee to breach their restrictive covenants by getting them to come and work for the new employer. And breach of contract is an essential element of the tort. It's not enough to show that action was prevented, or performance of the contract was prevented or interfered with. You must show that you induced or procured the breach. And that preventing or interfering might give rise to an unlawful means claim, but it won't be enough for an inducement claim. Dividing lines not clear cut, but this sort of arcane point doesn't often arise in employment claims. So what is the defendant's liability for inducement? Carelessness is not enough. A new employer doesn't owe a duty of care in negligence to the old employer. They're likely almost invariably to be competitors. They want each other to do badly. There's no duty of care. So you've got to show some form of intention. Secondly, you must know of the actual terms of the contract. Constructive knowledge isn't enough. But again, this sort of point doesn't often arise for employment lawyers, since everyone knows all employees are going to have contractual terms, and at a certain level, the chances are, unless you're turning your eye away from it, and you'll be caught with liability if you do that, you'll know that an employee is likely to have restrictive covenants in their contract as well, especially if you as an employer have restrictive covenants in your own employment contracts. But the last point on this slide, that it is key, that you can rely as a defence on legal advice that the covenant is unenforceable. And that's derived from the Court of Appeal case of Allen and Dodd, and the case that Charlotte Davis, who unfortunately isn't here, and I acted in last Friday, of Jump and Couture. It's unreported because we still haven't got the judgment, but hopefully it will be reported at some point. But in Jump, just like in Allen and Dodd, the new employer got legal advice, and the legal advice in both cases was these covenants look unlikely to be enforceable, and that's enough as a defence. So the employer can say, I was told they were unlikely to be enforceable. I had a genuine view, therefore, that they were unlikely to be enforceable, and I couldn't, therefore, have the requisite mental state of thinking I'm inducing a breach of contract because I didn't think there was an enforceable contract in place. If you can show honest doubt as to whether or not the contract is enforceable, that's enough. And the Court of Appeal considered it sufficient as a matter of policy that people can rely on legal advice, which we should all be grateful for as lawyers. Conspiracy, as distinct from inducing a breach of contract. Why would you ever bring a conspiracy claim? Well, you might not have a contract in place. You might, for example, only be relying on equitable obligations of confidentiality. So if my employer has breached their obligations of confidence and there was some form of combination or agreement to breach those obligations with a third party, I might only be able to rely on a conspiracy claim rather than inducement of breach of contract claim. There are various elements of this. First is that there must be an agreement. That falls short of a contract. You just need some form of combination, not a contractual combination. And the importance of this is the fact of the combination is that you can use it in clever ways. So directors can conspire with the company they act for. And that might be really useful if the company is insolvent and you want a solvent defendant to aim at. And you've only got, and it's the company that's acted in the way that you say is conspiratorial. Secondly, there must be concerted action. Passive facilitation isn't enough. And thirdly, you need to prove damage in order to have a cause of action. It's part of an element. One of the elements of the cause of action is damage. And this can be tricky as employment lawyers if we've got, for example, a number of defendants in different jurisdictions, because you have to prove damage here in this jurisdiction in order to bring a claim here. So if you've got an international claim against a number of different conspiring defendants, you've got to think about where the damage is suffered in order to bring that claim. Pros and cons of alleging conspiracy. First, you don't need to show that it's the predominant purpose of the defendants. You just need to show that it's one of the purposes. If a conspiracy is aimed or directed at another person, and it can be reasonably inferred, in other words, from an objective perspective, that the conspiracy may injure that person, that's enough. Secondly, there's no need to show that the claim is actionable by the defendant. So there was some judicial discussion in OBG that, for example, an unlawful means conspiracy the unlawful means themselves had to be actionable at the hands of the defendant. But in Total Network Solutions, the House of Lords said that's wrong, and that you do not need to show that the unlawful means are themselves actionable at the hands of the claimant. So the advantage for a claimant is that relying on unlawful means conspiracy gives you a wide scope, being able to rely on crimes as well as civil wrongs. And thirdly, you can bring claims against a wide number of people, not just the defendant against whom you've got a cause of action. What are the cons? Well, first, you've got the burden of proving the conspiracy claim with all the strictures that I've talked about. And that means that quite often, even if you've surpassed that burden, there'll be applications by defendants for strikeout or early hearings to determine aspects of the claim. Secondly, it's unlikely you're going to have direct knowledge of the fraud, except in cases that I've been cursed with, like Ivy, where the client actually writes down their stupid fraudulent schemes. It's in the main, you don't have documents showing that they're fraudulent. And lastly, something I highlighted as a pro can also be a con, that if you've got multiple defendants, not multiple dependents is a con as well, but multiple. If you've got multiple defendants, it can be expensive, and the more barristers and solicitors there are against you, the more clever points they will be coming up with. So lastly, I think I'm bang on 40 minutes, some litigation tips. In fraud claims, information is key. The courts consistently emphasize that when determining fraud claims, the witness evidence and the oral testimony is much less important than contemporary documentation. So marshal documentation at the beginning, and think about the maths too, because having spreadsheets and documents attached to your particulars of claim can give you a huge advantage when litigating. And the more clearly you can present your claim at the outset, the better going forward. Secondly, disclosure. Defendants will often have destroyed documents in where there are allegations of fraud. And so as a claimant, think about interim applications for delivery up and specific disclosure orders, and also think about writing letters saying these are the documents and heads of documents that we expect to see in disclosure. And if you don't get it, then you'll either tee up a specific disclosure application, or you can ask the court to draw adverse inferences. Thirdly, costs. The standard order for a successful claimant in a fraud claim is indemnity costs. The flip side is that you might well have indemnity costs ordered against you if you've made an unsuccessful allegation of fraud against a defendant. And lastly, funding. This is often important in fraud claims, not simply because you're dealing with insolvent defendants quite often, but as a claimant, think about getting freezing orders and think about what approach, and you can get freezing orders even in support of claims in the employment tribunal. So it's not simply high court claims that you should have a think about freezing orders in, but think about the standard orders that go along with freezing orders, like what's called the angel bell exemption, allowing a defendant access to legal funds in order to fund the litigation. If you bring a proprietary claim, maybe it's based on a fiduciary duty or a bribe, the angel bell exemption doesn't apply. And in certain circumstances, you can apply to remove the angel bell exemption. So think about those.